Upon the passing of a boyfriend, whether or not the girlfriend would be entitled to receive benefits from his estate would depend on whether or not he had made a will. If the deceased boyfriend had made a will and he had provided for her under the will, then yes, she would be entitled to receive benefit from his estate. If, however, he did not make a will, then the distribution of his estate would be governed by the Intestates Estates Ordinance. And under this ordinance, girlfriends are not a class of beneficiaries which are recognized, and therefore she is unlikely to be able to receive benefit from his estate.
Where a boyfriend wishes to make a will, it is always highly recommended to consult lawyers to ensure that the will, of course, properly provides for all the people that the boyfriend should be providing for. This would help in assisting in avoiding litigation or other disputes in the event of the boyfriend passing away. Now, one can understand that there are sensitivities involved in naming or expressly providing for girlfriends or other people in similar situations on the face of the will itself. Now, in these situations, again, it is highly recommended to consult lawyers because there are techniques that can be employed to provide for financial dependents, girlfriend, and others without necessarily naming them on the face of the will. Another matter to take into account is that if a will does not properly provide for financial dependence, and if a girlfriend is a financial dependent of the deceased, then there is every possibility that the girlfriend might qualify under the Inheritance Provision for Family Independence Ordinance as a financial dependent to ask for maintenance to be provided to her.
The short answer is no. For the purposes of the Intestate Estate Ordinance, it does not matter whether or not the deceased boyfriend was married. As I mentioned before, girlfriends are not a class of beneficiaries recognized under the ordinance, and hence whether or not the boyfriend was married is not of significance. What the girlfriend can do is, if she was previously provided for by the boyfriend prior to his death, she may make a claim against the estate under Cap 481.
Where the boyfriend has made a will, ideally that will should provide for all persons who he is financially responsible to, including, of course, his widow and his girlfriend. But where we're talking about a situation where there is no will, then, of course, whether or not the boyfriend is married would not affect the girlfriend's status to make a claim if she is a financial dependent. However, it may make a difference in terms of the court's exercise of discretion, because where the boyfriend is married, the court would have to consider the interests and financial needs of the spouse, what is reasonable for the spouse, the widow, as well as a girlfriend. Whereas if the boyfriend was unmarried, then of course there would be one less person, namely no widow, to take into account.
In order to establish her claim under Cap 481, the girlfriend would need to show that the disposition of the deceased boyfriend's estate, either by his will or according to the intestacy rules, does not make sufficient financial provision for her. And in order to prove this, she would need to show that prior to his death, he was actually maintaining her financially so that she can show to the judge that she was receiving financial provision from him.
And in order to prepare for such a claim, it's highly recommended that the girlfriend should be collecting evidence of financial support and financial maintenance coming from the boyfriend for the period immediately prior to his passing away. Also relevant would be receipts, invoices, and other documents showing her own expenses and her own financial needs. Important to bear in mind is that there is a time limit for filing such a claim. These claims must be filed within 6 months of the grant of probate. So the moment you see a grant of probate in progress, it's very important to start collecting all the evidence and to make sure that the claim is filed within the 6-month time limits.